Thank you. Welcome, everyone, to the Best and Brightest Elite Suite Education Series, and thank you for joining us. I'm Jan Hubbard, and I work on the educational program for Best and Brightest companies around the country, or really I can say around the world, because I understand we have someone from Buenos Aires on today's call. So let's make sure that you understand, as the operator instructed, you are invited to submit questions during the program, and I'll monitor these throughout the presentation, so please feel free to chime into the discussion and we'll cover them at the end. We'll be using the raise your hand feature, and I think most of you have been testing that. So if you haven't yet, take a look and make sure you can use that feature, because today's program is interactive. Following the program, you'll receive from me a SurveyMonkey evaluation, and in that evaluation will be your opportunity to apply for 1 unit of continuing ed credit, and that will be the only way you'll receive a certificate is through that SurveyMonkey evaluation. So I'm pleased to introduce to you Rebecca Davies. She is a shareholder based in Butzel Long's Detroit office. She received her undergraduate degree from the University of Michigan and her Juris Doctorate, magna cum laude, from the Detroit College of Law. She also completed the master's program at Wayne State in labor and employment law. Rebecca concentrates her practice in the areas of employment law and represents employers with 2,000 to 20,000 employees in federal and state court litigation and before state and federal administrative agencies. Her greatest success, however, are in her efforts to prevent litigation, mitigate the risk, right? She regularly counsels employers on compliance and state employment laws, and drafts employment policies and advises on preventive strategies. She holds certifications from both SHRM and HRCI, and is a SHRM certification instructor, as well as a frequent speaker on employment law. Last year, she was named the 2017 class of Michigan Women in the Law by Michigan Lawyers Weekly, and she was voted Most Valuable Professional by Corp Magazine. Many of you know that we are starting human resource peer groups launching around the Best and Brightest regions, and Rebecca facilitates 2 of those. At the end of today's presentation, we'll have a link where you can get more information on the peer groups, because we're also starting a new virtual group so we can get them from around the country, get people from around the country. So, Rebecca, I'm going to yield the floor to you after your walk-up song.
Thank you so much, Jan. Thanks for having me, and thank you to the Best and Brightest for having me as well. Can everybody hear fine? I saw some comments that the sound was low. So if you're having any issues, please make sure that you let us know that.
Right.
I am having some feedback all of a sudden. There we go. Maybe it's just the music. So why don't we get started? As Jan said, this is not a spectator sport. So if you have not located your raise your hand button, please do so. I was told it's at the bottom left of your screen. If you have it, raise your hand and let me know. Oh goodness, only 5 people raised, or 5 people actually listening right now. Oh, look here we go. Now we're looking at it. Excellent. The reason why I'm asking you to do this is because we are going to go through a series of questions in which you have to tell me what you think the answer is. And why are we doing that? Well, 2 things. 1, it keeps you involved. And 2, it lets me know whether this is an easy question or a difficult question for you. And then based upon your response, I get an understanding of whether I need to address this in a little bit further detail or just skip to the next one because you're bored and you want to hear something else. So thank you everybody who has raised their hand. It's tricky. You got to raise your hand, and then after you get done raising it, after the question, you have to click the button again to clear that out. Okay? So let's get started here. Today's presentation is Embracing Change. We are going to address some of the changes under the Trump administration with respect to employment law. I am not trying to be politically active or present any position except just to tell you I am a management side attorney. I represent employers. And so when I can highlight some of the positive issues coming from the agencies or the courts, I will try to do so, as well as counsel you as to what you need to be prepared for. So with no other delay here, let's get started. The first issue I wanted to talk to you is about the Department of Labor. As you may know, the Department of Labor appointed Alex Acosta as the Secretary of Labor, and President Trump's first year has been deemed a success by management side attorneys like myself just because of one appointee, and this is the Department of Labor Secretary. Let's examine some of his efforts. And this brings us to your involvement. So the first question on tap is true or false? The overtime rule has been officially scrapped. As you may recall, on December 1st, 2016, the new overtime rule was set to take effect. It was supposed to raise the salary level from $23,660 to $47,476. On November 22nd, 9 days before it was supposed to take effect, the Northern District of Texas judge issued a stay as to that final regulation, holding that the Department of Labor did not necessarily have the authority to adjust the salary level. Since that time, a new administration has taken office, and there has been issues with respect to where is the status with respect to this overtime regulation. So I ask you, true or false, the overtime rule has been officially scrapped. If you believe that's true, you raised your hand. And the answer is false. It's not over yet. It's not over yet. The Secretary of Labor has asked the Fifth Circuit to affirm his power to set a salary test for overtime exemption, which is kind of ironic because the basis for the district court's decision was that the Department of Labor did not have that authority. So where we are now is that the Department of Labor issued its regulatory guidance in the fall, and it said that it sees that it will issue a proposed overtime rule by October 2018. And the jury is still out as to what that level is going to be. However, all the tea leaves point to an inflation-adjusted salary level in the low 30s. In fact, the Society for Human Resource Management has recommended to the Department of Labor to raise the salary threshold from $23,660 to $32,000 annually. In my humble opinion, never to be humble opinion, I think employers may be hard-pressed to contest that $32,000 increase annually. But again, we have to wait to see what the Department of Labor will issue on that. Okay? Before we get started, if you were kind enough to raise your hand, you can unclick it. Otherwise, it will appear to be a true answer for the next one, and I want to give you a full opportunity to answer that. So if you have your hand raised, you can unclick it and we can go off to the next question. Okay. True or false? It is now more difficult to classify a worker as an unpaid intern. True or false? It is now more difficult to classify a worker as an unpaid intern. If you believe that is true, you're going to raise your hand. Otherwise, I'm going to assume that you believe it's false. Not that you're not paying attention, that you truly believe it to be false. Okay. And the answer is false. Good news, everyone. On January 5th, 2018, the Department of Labor adopted a primary beneficiary test for determining whether interns are employees. In so doing, the Department of Labor abandoned that rigid 6-factor test. The courts have described the primary beneficiary test as a flexible test, and that no single factor is determinative. So if you go through this analysis and you determine that the intern or student is actually an employee, then this intern or student would be entitled to both minimum wage and overtime under the Fair Labor Standards Act. However, if you go through the analysis under the primary beneficiary test and you determine not an employee, then you're not required to pay either minimum wage or overtime under the Fair Labor Standards Act. So let's go through this test in a little bit more detail so you can truly understand it. Under the primary beneficiary test, the first factor is that both parties understand that the intern is not entitled to compensation. So, how is that done? How do you make sure that both parties understand that the intern is not entitled to compensation? Well, that's generally is best done by some sort of written documentation, being an agreement acknowledged and signed by the student or the intern, or some sort of letter or correspondence issued by the company to the student and the intern, so there can be no second guess as to what the relationship is. The second element is that the internship provides training that would be beneficial in the educational environment. What does that mean? That means that you are not using that student or the intern only to learn about your company. Okay. Instead, you're trying to give them general knowledge either in the industry or in their position or practice which they're trying to develop. So something that would be overall beneficial if they went to any company, not just necessarily yours. So again, this factor goes to the true educational component of a student or an internship. The third factor is that the intern's completion of the program entitles him or her to academic credit. Now, some employers do not necessarily have this connected to academic credit, and I want to remind you that you do not need all elements, but again, this points to the educational proponent of having an internship. Internships are not just summer free labor here. We are trying to make sure that they get an educational benefit from this. The next requirement is that the internship corresponds with the academic calendar, and that goes along with the prior factor that we just discussed. And the other factor on the slide is that the internship's duration is limited to the period when the internship educates the intern. So what does that mean? Is that you cannot necessarily convert afterwards. You're not saying, okay, I'm going to hire you as an intern, and as soon as you're done, you're automatically going to be an employee. You cannot necessarily guarantee employment afterwards. You could give employment afterwards, but it can't be guaranteed. The next factor regarding the primary beneficiary rule for the intern test, I believe, is the most important. And that is that the intern work complements rather than displaces the work of paid employees. So what does that mean? That means that you cannot have two individuals working side by side doing the same type of duties and requirements for the employer, but one is a paid employee and one is an intern, an unpaid employee, an unpaid person. So if you are trying to hire interns necessarily just to displace or complete the work that you would previously have done by a paid employee, you may be running afoul of that internship program. And then finally, the last requirement for this test is that there is no guarantee of employment. Now, in a vacuum, how do you do this, right? These are all nice generalities with respect to this is what the required test is. But how do you go back and make sure that you are following these requirements under the primary beneficiary rule? Well, you want to make sure that you're not treating your interns like employees, that they do not fill out an employment application, that they're not covered under the employee handbook. You want to make sure that you're defining them and following that definition throughout their time with your company. So how do you do that? First of all, you have clear policies that address what an internship is. So we started off saying that the first requirement under the primary beneficiary rule is that both parties understand that the intern is not entitled to compensation. So that would be probably our first policy or form or agreement that addresses that with respect to what are the goals of the internship, what is the length of time, and that it's an unpaid position. Now normally, during the course of employment, you would evaluate your employees based upon their performance. Again, students or interns that are unpaid, and I want to emphasize we're only talking about the unpaid internships right now, do not necessarily receive performance evaluations. And you can critique their ability or address some of their issues that they need to improve, but we want to do this with respect to goals. So it probably is the best way to address this is that at the beginning of the internship to discuss what are the goals at 30, 60, and 90 days. And then at those points of time, address whether the internship has met those goals. Have they had the opportunity to do this type of work or been exposed to view this process that your company completes? And so that will give them an understanding of what the expectations of the program are, and it will also give you an issue with respect to how to keep yourself accountable, that you can follow this in a 30, 60, 90 days. Okay. Before I get off of the issue with respect to internships, I want to make sure I emphasize that what I'm talking to you about right now, the primary beneficiary rule, is a federal law. So I want to emphasize that we have employers from multiple states here, that you need to check your state law on internships and payment of wages and ensure that you do not have a stricter state law or city ordinance even, because those laws would apply. You would get the benefit of those laws. Okay, so this is just basically the new federal test. Make sure you consult your state or local ordinances to see if there's any differences. Okay. Before we go on, I ask if anybody has their hand raised. They can click that and clear it off because, again, it's back to your participation. Okay. The next question we have, true or false, is employers with at least 100 employees must submit annual EEO-1 reports that include W-2 pay and hours worked data for their entire workforce. Okay. There were lots of issues with respect to now changing our EEO-1 forms, which are only required for those companies that have more than 100 employees or federal contractors or subcontractors. And we were going to now change this to add the pay information. And it was a way to combat discrimination with respect to the genders. And that was, and where do we sit on that? So are we required to provide it? And the answer is false. We are not required to provide it. So what happened is this is kind of messy. And I'm going to get you to where we're at, but let me give you a little bit of history here. On August 29, 2017, the Federal Office of Management and Budget stayed the implementation of the new EEO-1 form. Okay, that was the EEO-1 form that was proposed by the Obama administration that would now address information regarding pay and hours worked. Okay, so what happened is, as a result, the old EEO-1 form prior to the Obama administration became the new form. Okay. And because of all of the confusion, because it was issued, the stay was issued on August 29, 2017, they pushed back the time period in which you had to respond. So generally, the office collects that information in September time frame, so that was pushed back to March 31st, 2018. So if you're a large employer, you know the answer to this because at least 2 weeks ago, you would have had to file your form, and that would not have been completed that information. So do you have to fill out an EEO-1 form still? The answer is yes, but it does not necessarily have to include salary information. Okay? It does not include salary information. So what does that mean? Is this off the table? Is this dead in the water? Well, not necessarily, but if I had to predict, I would be predicting that this is not something that we're going to be seeing anytime soon, and this is why. In commenting about the stay, the acting chair of the EEOC, Victoria Lipnick, who was one of the members who voted against the updated EEO-1 form, stated that while the EEOC remains committed to strong enforcement of federal equal pay laws, she hopes that the OMB's decision will prompt a discussion of more effective solutions to encourage employers to review their compensation practices to ensure equal pay and close the wage gap. So what happened is that the Office of Management and Budget notified the EEOC that it was required to submit a new information packet. There is no deadline for the EEOC to do this, and based upon the comments of the acting chair, it does not appear to be a high priority item. This is good news for employers in that the administration of this new form and collecting all this information appear to create administrative nightmares for many companies. Okay, we're going to clear our hands raised and go off to the next question. Sticking with the Department of Labor, true or false? The Department of Labor scrapped a rule requiring businesses to disclose when they hire anti-union consultants. True or false? The Department of Labor scrapped a rule requiring businesses to disclose when they hire anti-union consultants. Now, when I refer to this rule, what I'm referring to is this rule called the Persuader Rule. And what that rule did is it made it harder for employers to receive legal advice on unionization efforts. And the good news is that this answer is true. Okay. So what happened is in June of 2017, the Department of Labor released a proposed rule to rescind the Persuader Rule. Under the Persuader Rule, if a company, outside of the Persuader Rule, if a company is worried about whether its workforce will unionize, they could hire a consultant and persuade the employees not to unionize. Under the Persuader Rule, that transaction would need to be reported. In fact, the Persuader Rule went so far to include that if you employ an attorney to provide advice with respect to unionization, you too would need to report that. And many attorneys argued that that flew in the face of the attorney-client privilege in disclosure of the content of communication you had with your clients. The rule even went so far, just so you could understand how broad it was, is not only did it address consultants, not only did it address going and broaching the attorney-client privilege, it also went so far to report attendance at seminars that had anti-union advice. You would have to disclose that a presentation was given by the certain presenter, and everyone who was in attendance would have had to be identified in this database. So having this rule rescinded back in June 2017 was again good news for employers. Okay, we're going to go to the next question if you want to click off out of your hand raised. True or false? Funding for the Department of Labor is set to increase in 2019. True or false? The Department of Labor will be receiving more monies come the 2019 budget. And the answer to this is false. The Department of Labor's funding is actually going to be cut by $2.6 billion under the proposed budget. That being said, the proposal still includes support for priority positions such as apprenticeship and employer compliance programs. So it's here to educate and not necessarily penalize employers, is how the new administration is describing itself. That it can achieve its goals more from education and compliance rather than punishment. There was some discussion previously that if they cut the monies, that they would be consolidating the EEOC and the OFCCP, which addresses affirmative action programs. But that issue or rumor, or whatever you want to call it, has not been addressed. So it is instead looking just at a proposed budget decrease and looking more to compliance efforts. Let's go on to the next question. True or false? The Department of Labor has reissued opinion letters from prior administration. True or false? So there previously were wage and hour letters issued by the Department of Labor regarding certain issues, such as some of the exemptions under the Fair Labor Standards Test, how to apply them, or issues with respect to deductions, or issues with respect to specific positions. So under the new administration, what is the Department of Labor opinion as to these prior opinion letters? The good news is the answer to this question is true. The Department of Labor has reissued 17 letters as to their issues with respect to a variety of issues, from everything from deductions for full days off, bonuses, and exemptions. Now what happened is that in 2010, the Department of Labor dropped this practice in favor of issuing broad administration interpretations, which would announce the Department's views on various issues. This was seen by many as an effort by the Department of Labor to exert greater influence over the development of law without recourse of giving time-consuming rulemaking or legislative process, that they would not have to go through those. Unfortunately, what it meant to employers is that they lost a wonderful, useful source of guidance. And while some prior opinions remain generally available, unless they were expressly withdrawn, no new letters were issued after the change in policy in 2010. So we had not only the 17 opinion letters being reissued, but we're looking to see now that we are hopefully going to get new opinion letters issued on particular issues. So with that, I wanted to share with you that anyone who wishes to request an opinion letter can find that information at this link. Okay, it's on the Department of Labor's website. And while employers can certainly go and get their own guidance, sometimes you may want to request your employment counsel to seek that on your behalf. Therefore, you as the employer would remain anonymous in issuing that guidance. Again, that would be a case-by-case decision for you to make, but I wanted to give you that possible issue that you might want to consider before you ask for guidance of whether you in fact want to have your name attached to that or instead do that through your counsel. Okay. So we've talked about the Department of Labor in great detail. There are many different agencies that address labor and employment issues, so I think we need to flip to a new one and go off to the National Labor Relations Board. In the olden days, people used to think that the National Labor Relations Board only applied to unions, and if they were a non-unionized workforce, they did not necessarily have to consider the NLRB's rules or requirements in their activities. What we found out in the latter years of the Obama administration is that the NLRB really inserted themselves into a non-union work environment and addressed issues such as confidentiality agreements and employment policies and handbooks which they believe to be violating Section 7 rights of employees. So let's talk about where we are under the National Labor Relations Board under the Trump administration. So if you already have clicked on true and you want to erase that, that would be good, because here we go with our new question. True or false? Despite having a Republican majority, the NLRB has been unable to overturn any prior decisions as we speak. Despite having a Republican majority, the NLRB was unable to overturn any prior decisions. True or false? Okay. And I truly appreciate everybody participating in this. And I'm going to assume that if you don't have your hand raised, you are active, but you've chosen this to be false, right? Of course that's true. Okay? So the answer to this question has to do with respect to who is on the board. Now, as you may recognize, the NLRB board members are appointed by the administration. So generally, they reflect whether there's a Democrat or Republican office. The board tends to reflect that in the members that are chosen or appointed. But simply because there is a change in the administration does not necessarily mean we flip a switch. Okay. Instead, these members to the National Labor Relations Board are appointed on staggering 3-year terms. So it takes a period of time to reappoint somebody based upon who's in the administration. As we sit here today, the Republicans are now finally in the majority. Okay. So the question was, has the NLRB, the NLRB was unable to overturn any prior decisions, and the answer is false. No. The NLRB has overturned a series of rulings that the management community has argued were too favorable to unions. And there is probably more than a handful that I could discuss with you. But I didn't want the presentation to be only addressed to this, so instead I went and focused on one of them. One of the most important ones was the Lutheran Heritage Standard. Okay. And that allowed facially neutral work rules to be found unlawful. So you had a work rule which on its face looked like it served a legitimate business reason, but if the NLRB felt that employees would reasonably construe the language to prohibit Section 7 activities, it would be found unlawful. So not necessarily what your policy said, but the NLRB's interpretation of what your employees would reasonably construe that language to mean, which was very difficult for many employers. So would your policy appear to interfere with the ability to engage in concerted activity, which is the ability to talk about the terms and conditions of employment? Well, if the NLRB held that it would reasonably construe it to prohibit it, then you would be found your language would be unlawful. The good news is that that standard has been rescinded under the new standard, which is the Boeing standard. And instead, the board is to evaluate, when they look at facially neutral policies, two issues. Number one, the nature and extent of the potential impact. Okay. So is it going to interfere? Is it a likelihood it's going to interfere? Right? We talk about risk analysis all the time in the HR world, but if it's an issue of a risk that never is going to come to fruition, is it something that we necessarily have to devote our time and resources to at this time? And that same analysis was held by the National Labor Relations Board. First, they look at the nature and the extent and potential impact of the national labor rights and the legitimate justifications associated with the rule. So the NLRB is actually letting the employers describe or defend its policies as to legitimate business issues. Okay. As I discussed before, there were 10 other issues or guidances released by the National Labor Relations Board on a Sunday, yes, a Sunday. And they addressed a variety of issues, including how to address Facebook accounts and other issues. So the good news is that we are now under an era with a kinder, gentler National Labor Relations Board. Okay, so under the topic of National Labor Relations Board, before I jump off of it, let's talk about joint employment. Okay, now that I just told you we have a kinder, gentler NLRB, is demonstrating joint employment more difficult under the National Labor Relationship Board? True or false? Demonstrating joint employment is now more difficult under the NLRB. I talked about a series of decisions that are guidance that was issued that were more employer friendly. So most people would believe that the same would hold true with respect to joint employment. And if you're not familiar with it, the Browning-Ferris decision that was issued under the Obama administration found joint employment situations in areas that were not necessarily previously held to be joint employers. It was a broader interpretation of what a joint employer was. So the question is that under the new NLRB, is it more difficult? And the answer is, unfortunately, yes. So how did this happen? I just got to share with you before that, hey, wait a minute. This was a kinder, gentler board, and we're seeing more favorable decisions for the employers. But what happened is that on February 26th, in 2018, the National Labor Relations Board threw out one of its most important victories in 2017. And the reason they did so is that there was an issue with respect to a potential conflict of interest that tainted the vote. Specifically, what happened is that in December 2017, there was a new decision under the case name of Hybran, which reversed a controversial Obama-era joint employer decision empowering workers to pursue claims or seek collective bargaining with major corporations that didn't sign their paychecks, such as franchisors, or you could go at clients of contractors. But what happened is that the vote that one that happened in December 2017, included support from the newly appointed Trump representative, William Emanuel. The problem is that Mr. Emanuel's former law firm represented one of the companies back in the original case in Browning Ferris. So the NLRB Inspector General issued a report that there was a serious conflict of interest issue, and that the NLRB responded and voluntarily withdrew the Highbrand decision of 2017. So what does that mean? The Browning-Ferris rule, the one that you could seek joint employment against possibly franchisors or clients of contractors, is now again once law of the land. That being said, there may be some other cases in the pipeline that the National Labor Relations Board can take up and address, and again issue a decision possibly consistent with their decision in 2017, deciding in the Highbrand decision. There is also a bill that was passed by the House that would overturn the Browning-Ferris standard, that difficult standard, but that has been yet to be taken up by the Senate. So we are going to have to stay tuned, and that is why I thought this emoji was also appropriate in my legal description of where we're at. Okay. Let's flip to another agency that regulates our practice here in the labor and employment end, and that is the Department of Justice. The first question is, if you want to erase and we can restart again, under the Department of Justice issue is that it is the Department of Justice current position that class action waivers in arbitration agreements are valid. Okay. It is the Department of Justice current position that class action waivers and arbitration agreements are valid. Okay. Now, what does that mean? That means that sometimes employers have agreements with their employees that any disputes would be resolved by arbitration. In those arbitration agreements, many employers would say, yes, you are required to do this by arbitration, but we will not be arbitrating this on a class-wide basis. We are not arbitrating issues, class actions. So does the Department of Justice believe that having those waivers and arbitrations to be valid? And the good news is that the answer is true. Okay? Yes, true. So what this means is that under the Obama administration, the Department of Justice argued that these agreements violated the National Labor Relations Act. So this determination by the Department of June in 2017, when they filed an amicus brief defending the legality of having these waivers, changed that position. Okay, a change that, again, as a management size attorney, I believe is appropriate. So let's really think about what this means and what the implications would be. So for a minute, close your eyes. Don't close them too long during this hypothetical because I don't want you to fall asleep, but close your eyes and imagine how difficult it would be to defend an arbitration if it was on a class action basis. Okay, so we're talking about multiple plaintiffs involved. Okay, imagine this arbitration that would be a class action arbitration, how costly it would be, right? We're not going before a judge, we're going through an arbitrator. And how is an arbitrator paid? By the hour, right? So cha-ching, cha-ching, cha-ching. Right? Think about how costly it would be to try to defend a class action in an arbitration setting. Okay. Personally, a few years ago, I was involved in such a case. We argued that the contract did not allow for class action arbitration. And who made the decision of whether it was initially, who made the decision of whether it was subject to class action or not? was the arbitrator. Okay? So guess what the arbitrator determined? Okay? Now the arbitrator is the decision maker. The arbitrator has a financial interest because obviously it would be the hours involved would be far greater if it was on a class action basis. I mean, let's be honest, it's basically a cash cow for an arbitrator, right? So not too surprisingly, in that case, the arbitrator held, yeah, this you can. It's not barred by the contract. This class action can proceed as an arbitration. Luckily, the Court of Appeals or the appellate court for that decision held differently, that arbitration was not allowed on a class action basis. So the good news is that we sit here now with the Department of Justice holding the same, that you can have waivers of class action suits in your employment agreements if it provide for arbitration. So some of you may have changed your arbitration agreements based upon this. If you did, you might want to review that language to make sure if that's your choice to have a class action waiver, that this be reinserted. Okay? So true or false? Let's go to the next question. True or false? It is the Department of Justice current position that Title VII of the Civil Rights Act does not forbid workplace discrimination on the basis of sexuality. True or false? The Department held that Title VII does not address with respect to on the basis of sexual orientation. The issue is that Title VII prohibits discrimination based upon sex. So what has been at odds is what is based upon sex. Okay? Unfortunately, the answer to this question is true. The Department of Justice actually went and argued in a Second Circuit decision that that sexual orientation was not protected. Interestingly enough, the party arguing for the other side was no other than the EEOC. Okay, so I call it the EEOC versus the Department of Justice. So the Department of Justice had a stand specifically at odds with the EEOC. The decision was made on this issue, though, and that was just recently addressed on February 26, 2018. And the Second Circuit held that discrimination which is based upon sexual orientation violates Title VII. Okay? And so what happened is that there was an en banc decision, which means when not generally just the the judges that are assigned to that case, but instead the entire panel gets together and makes a decision on a case, which turns it into an en banc decision. And they broke with their own precedent and revived a sexual bias claim brought on behalf of the plaintiff based upon sexual orientation. Okay. Now, I know we have many participants here throughout various states, and a majority of them come from the state of Michigan, where we're based out of. I want to emphasize that the Second Circuit has limited application, and it does not include states such as Michigan. So we have to address what is the practicality of this and how does it affect your organization. Many times employers say, well, do I include this in my employee handbook as a prohibited act of discrimination or not? The issue is that, whether you address it or whether you include it, you may do so even though the law does not necessarily require you to do so, but you might want to counsel or advise your executive and management team that as the moment, if you're here in Michigan, this is not necessarily legally required. So I believe just as we had with respect to the application of same-sex marriages and whether they are recognized in the various states, hopefully we're going to get a definitive answer with respect to this issue that we can be consistent throughout the country. Okay, so given that this is a legal presentation, let's talk about the courts as well. True or false? Whistleblowers must report to the SEC in order to receive Dodd-Frank retaliation protection. True or false? In order to receive protection for whistleblower, you actually have to go and make a complaint. What do you think? If you think yes or true, raise your hand. Excellent. Okay. And the answer is true. The United States Supreme Court just recently unanimously held that in order to receive the protection, you have to actually report it. Okay. With respect to this issue, what happened is that the employee went and reported it to the employer. Okay, and that was not enough. You have to go to a third-party agency. And this is logical and is actually consistent with many state laws that address whistleblower protections, in that you don't get that protection under the Whistleblower Act unless you threaten or report it to an outside party. So just telling the company itself that you disagree or that it violates it was not enough to engage with whistleblower protection activity protections. Okay. Let's go through another issue with respect to some of the recent decisions. True or false? It is optional, but not required for employers to provide applicants with a copy of the background check and pre-adverse action notices. Okay? And I'm talking about the pre-adverse action notices discussed in the Fair Credit Reporting Act, that this is optional but not required. True or false? And the answer is false. Employers must comply with the Fair Credit Reporting Act requirements. Okay? And why am I bringing this up to you? Is that this has been kind of the soup du jour of employment class actions, and the plaintiff bar has been flooding the courts with lawsuits asserting technical violations of the Fair Credit Reporting Act. And let me share just a couple of you real quickly. One of them is with respect to against Southwest Airlines. And the plaintiff did not accuse Southwest of ignoring the Fair Credit Reporting Act outright, but rather when it provided the statutory notice, it gave him along with other extraneous information, so the plaintiff did not recognize it. The good news is that the court felt that that wasn't a willful violation. Okay. The other issue brought is that predetermination. There were two cases, one against Geico and one with respect to against Walt Disney, and they both kind of addressed the same issue. And that is that both organizations coded the employee status as a possibly no hire situation based upon certain criminal convictions. The case in Walt Disney held that, well, that wasn't necessarily a final determination, and it wasn't a willful violation, and the court sided on Walt Disney. Unfortunately for Geico, the court denied judgment in favor of Geico when an employee told or testified that on the day of getting that initial grading, the plaintiff's job offer was rescinded. So that rescission of the job offer seemed to be very final and not necessarily something that was going to be addressed at a later date. So the basis of the reasons why I wanted to include this is I wanted to emphasize with you that you need to make sure you're following your Fair Credit Reporting Act requirements, and even technical violations can be seen to be violating the rule. Okay, now we're off to new and proposed regulations. True or false? The Department of Labor has proposed a rule which reduces the number of workers that could share in gratuities under the Fair Labor Standards Act. True or false? We're going to be reducing the number of people who can be involved in the tip pool. The answer to this is false. Okay. Currently, as we stand here today, restaurateurs can allow front of the house staff servers, bartenders, bussers, okay, to pool their tips. Okay. The proposed rule would make it clear that they could share it with those who traditionally don't receive gratuities in the back office. But if we're going to do the back of the house staff, such as cooks and dishwashers, what would happen is that they cannot necessarily receive that lower tipped wages. They would still have to receive the regular minimum wage. Now, this was a issue that was open for public comment, and that period closed on February 5th. So we are awaiting a decision from the Department of Labor based upon the public feedback. So stay tuned, all of you restaurants, with respect to how or if the changing with respect to tip sharing will be affected. Our next question under proposed rules or regulations is true or false. An employer may receive a tax credit if they provide paid FMLA. True or false? Employers may receive a tax credit if they provide for paid FMLA. And you should have lots of hand raised because this is true and this is good news. The Tax Act signed into law at the end of 2000 and created a 2-year federal tax credit for employers that provide paid family medical leave. Okay. Now, while the official guidance on the credit is forthcoming, it's a good time for you to ensure that you are aware of the credits and that you try to take benefit from it. Okay, so make sure that you and your accounting department is getting together and discussing this. True or false? Some states are prohibiting employers from asking about past salary information. True or false? Some states are prohibiting employers from asking about past salary information. Now, as you may recall, several years ago, the Department of Labor issued guidance, okay, which guidance is not the law, but guidance, best practices, that they believe that you should not ask for information on the application with respect to criminal history. Okay, some states prohibiting employers from doing this? And as I can see from many of the hands raised, you understand that yes, this is in fact happening with respect to salary information. Similar to the criminal ban the box for criminal background, some states are prohibiting employers from asking information about salary information. So if you're an organization that does business in multiple states, you may have to have either an application that doesn't address this, so it can be used in all states, okay, or a different application for those states which you are seeking this information. So right now it's prohibited in California, Oregon, Massachusetts, and Delaware, as you can see on this map. On this note, the Ninth Circuit just held, which the Ninth Circuit is the Federal District Court of Appeals that addresses the states of California and others, an issue with respect to asking about prior salary. And it's a very controversial decision. It was just issued this past Monday, and the Ninth Circuit said that generally what happens is that the Equal Protection Act prohibits just differential pay for men and women. You can't differentiate the pay simply based upon the gender. Okay. One of the affirmative defenses to that was that it's based upon a factor other than sex. So what happened in that decision is that the employer set the salary level based upon what the person made before, gave them a 5% jump, and then the employee later learned, wait a minute, the female plaintiff, I'm making much less than my male counterparts. And the employer justified it and said, well, we based it upon her prior salary, and she got the increase like everybody else did. The Ninth Circuit came and said that's not permissible, and that the exception for any other factor other than sex is limited to legitimate job-related factors such as an employee's experience, educational background, ability, or job performance. So it's very important that if you provide for that automatic based upon the salary, that you review those practices and see whether they're appropriate or legal with your counsel. And the last issue that I can't follow or ignore is that with respect to sexual harassment. I'm not going to revisit all the issues that we've had with respect to sexual harassment and the Me Too movement, but I want to talk about two particular issues that you as employers need to be aware of. And the first is true or false. The new Tax Act makes sexual harassment more expensive for employers. True or false? And I see a lot of hands raised because you know that the answer is true. Okay? Prior to the tax reform, what happened is that the tax code permitted employers to take a business deduction for the cost of obtaining a sexual harassment settlement. Okay? The new act, however, prohibits a deduction if you have a non-disclosure provision. If you have a non-disclosure provision. So very important for you to recognize your tax consequences differ if you have a sexual harassment settlement that requires an NDA. And then finally, I wanted to raise the point with respect to that some states are now requiring sexual harassment training. Okay, that California and Connecticut, if you have more than 50 or more employees, you have to provide for the training. In Maine, it's businesses with 15 or more employees. And in other states such as Massachusetts, Rhode Island, and Vermont, employers are encouraged but not necessarily required to provide that training. So states are getting into the business of actually advising employers of this requirement or encouraging it as well. Okay. The last issue with respect to it is that some attorney generals want to make sure that arbitration is actually banned for sexual harassment issues. And their reasoning for that was by banning sexual harassment issues to be arbitrated, it would likely limit the publicity, and maybe that's not necessarily a good thing. So we'll have to keep our eye on whether that actually goes forward or not. I recognize that I'm 2 minutes past the end of the presentation. I apologize for running 2 minutes late. If you have any questions, you can see my email address here at davies@butzel.com. Feel free to follow up and send me an email, and we can discuss any of these issues at further length should you wish. Davies, D-A-V-I-E-S, @butzel.com. And I would like to thank Jan and Best and Brightest for having me today.
Wow, Rebecca, thank you so much for that hour-long, packed full of information program. Thank you so much. And thanks to all of our listeners for participating today. The program was recorded, and by the end of the day today or tomorrow, the program will be on our Best and Brightest website. And again, you'll receive a Survey Monkey evaluation from me, and that will be your opportunity to apply for the continuing ed credit. That will be the only way that you can receive credit. So if you are interested in our HR peer groups, please log into the Best and Brightest website with the /peer-groups, and you can sign up for more information on those. I have a question. Can we have the slides? You can have the recording. Because laws change so frequently, we will be dating the program on our website, but definitely always use your own attorney and your legal counsel on updates. And again, Rebecca's email was available to you. So thank you again, and we'll conclude the program. Bye-bye.